Good afternoon. My name is Amanda Strainis-Walker, and glad to have you join us for our third webinar for this year's series. And we're going to be talking about OSHA's renewed site-specific targeting inspection program. Let's go through some introductions to put some context or some details to the individual voices you'll hear today, and I'll kick that off by giving a few details about myself. My name is Amanda Strainis-Walker, and I am one of the original OSHA partners in Conn-Maciel-Carey. I'm also one of the few attorneys who's practiced exclusively in the realm of OSHA. I started my career at OSHA, the national office in Washington, D.C., won't name what year, but getting to be longer ago, and then moved over to the solicitor's office where I also focused on occupational safety and health issues before making it over to private practice and helping employers and trade associations on a full range of matters regarding the OSHA Act, whether it's enforcement, rulemaking, variances, and a whole host of different issues that come out. I handle cases that from the inspection to determining whether a issue is reportable to OSHA under the reportability guidelines, and then going through the inspection, and if that does result in litigation, also handling the litigation until there's a resolution to the matter. In addition to OSHA, I've also worked on CSB inspections, RMP inspections that are under EPA jurisdiction, and do some MSHA work as well as DOJ. That usually means that there has been a criminal referral, and have certainly worked on those cases. A criminal referral is one where it originates from an occupational safety and health violation, and it's referred to the Department of Justice for further review. And then also working in the state plan states and also other local regulators. Turning it over to Aaron so he can do his introduction.
Thank you, Amanda. So my name is Aaron Gelb. I am, 24, working on 25 years as management side, OSHA and employment lawyer, something of a switch hitter. I manage the firm's somewhat recently opened Chicago office. We opened back in January of 2018. And like Amanda, I handle the full range of OSHA counseling, audits, proactive audits, and preparation for expected inspections, managing inspections, and contesting citations, and all the litigation that goes along with that for clients in the greater Midwest and beyond from time to time. And in addition to spending a good bit of my time on the OSHA side, probably certainly a majority of it, I do also do employment litigation, all manner of claims before the EEOC. I've tried a number of jury trials in federal court, in Indiana, Tennessee, New York, D.C., a number of arbitrations, a number of administrative law judge hearings, so fairly experienced on the litigation side as well as the counseling side. And with that, I will hand it over to Dan Deacon.
Thanks, Aaron. My name's Dan Deacon, and I am an associate here at Conn-Maciel-Carey, and I practice in both the OSHA practice group and the labor and employment group. I represent employers during inspections and investigations at the federal and state OSHA levels, advise and counsel employers in responding to notices of employee safety complaints and OSHA citations, and represent and advise employers in all aspects of the employer-employee relationship, including FLSA issues, claims of discrimination, harassment, and I also regularly assist employers in reviewing and revising employee handbooks and developing workplace policies and procedures. So with that, I'll turn it back over to Amanda, and we'll go over the agenda really quick and jump into the meat of the presentation.
Great, thank you. We're going to go over 5 main topics today. The first one is OSHA's SST program and its history, give a little background, and give some context to some more the details that we'll be discussing regarding the most recent one. OSHA's E-Recordkeeping Rule, which is closely mirrored with the current SST program, and then getting into the details that OSHA's released with regards to its current SST program or inspection plan, which is currently operating. We're hearing from employers that there are ongoing inspections out there based on this program's inspection program. The future of e-record keeping, we'll talk about that a little bit more in detail, and planning for an SST inspection. If you think that you're one of those employers, what should you be doing now? Starting off, let's dive into a little bit about the history. As I mentioned earlier, the new SST program, it's new in the sense that a new directive came out last year announcing that OSHA would be moving forward or renewing its prior use of the site-specific targeting program. The site-specific targeting program had been in existence for quite a while. I don't know the exact time that it started, but certainly goes back to 1995, and I think probably a little earlier than that. It came about as a result of jurisdictional issues and when OSHA had the probable cause to enter a work site. Their theory is that if an industry or a workplace has a higher than average DART rate for its industry, they think by going in and getting to the work site before incidents occur and helping them to come in compliance. So they're targeting those work sites that have the high DART rates, days away that result, days away and also days away from work that can be the result of transferred work or just employees away from work related to a workplace incident. So that's their thought. It's kind of the grandfather of programmed inspections. We talk a lot about LEPs, local emphasis programs, and national emphasis programs. This is kind of where programmed inspections started, so it certainly has been in the OSHA world for quite a while. And it focuses on employers with 20 or more employees that have primarily focuses on employers that have a DART rate that's higher than their industry average. And when I say it primarily focuses on those, we know that there's been a couple sets of employees that have been added into the random lists that are being created by the national office regarding employees who, or employers that OSHA thinks should have submitted their data through the electronic portal and did not, as well as those that have an unusually low DART rate for a high injury rate industry. So there's some of those samples in there to confirm information. OSHA's old program was more paper-based. There was a survey sent out to about 80,000 employers where they were asked to write their information from their 300A annual summary on a piece of paper and submit it back to OSHA. There was a warning that went along with this paper indicating that if you did not return it, you would be at a higher probability for inspection. So a lot of employers did return it. And OSHA would occasionally inspect those employers who did not return the piece of paper, and OSHA had a pretty good trail of who those 80,000 employers were out there. They would then create lists and go out and conduct program inspections. The ODI process was paper-intensive, cost for postage, and we saw a discontinuing of that paper-based system in around 2010, 2011 because of the cost. That's when the government was really trying to tighten its belt, and they felt as though that was one way they could eliminate some cost. So they retooled their data collection process, and so eventually we've got into e-record keeping, and so now OSHA is using the data that they collect electronically to base their SST inspections off of. Just so there's no confusion, the paper-based receipts that it would go out to employers to fill out with their 300A information is no longer coming from OSHA, but there's a separate sheet that some employees might receive, and I've talked to a couple of them this year, that is coming from the Bureau of Labor Statistics, BLS. And those two are often confused, and BLS continues with their same paper-based system that they use to get their injury and illness rates. And employers are still under an obligation to respond to those and susceptible to higher scrutiny if they don't return those. So those are still going out, but the paper surveys from OSHA are not. And like we talked about, these results would be used to calculate what inspections OSHA would go out and conduct. They called these programmed inspections because they are generated from a list, and they would go from there. Also, as part of the earlier SST program, usually employers would get a warning letter. I looked up on the database this morning, and it looks like, and I'd be interested to hear if any employers have received recent warning letters. I've not heard of that from any of our clients, but it looks like the last letters might have gone out in the March of 2013, and that was based on data that OSHA had collected in the paper-based survey in 2011. And these letters would go out indicating to employers that they had a higher than average start rate and that they might be inspected. Typically about 9,400 employers received these letters, and they, like I said, they were last based on 2011 data. To the best of our knowledge, those letters have not gone out recently. I think there's probably been some letters that have gone out regarding individual employers who did not respond to or submit their information in the 300A database, and OSHA thought that they should have submitted their data, and they've received a letter indicating that OSHA thinks they should submit that data, and if they've corrected it, great. Otherwise, they encourage employers to submit it. So this is, while it's a new directive, OSHA issues a directive for these programmed inspection cycles. It's a new directive with the SST program that had a lapse for a period of 3 or 4 years, and now we are continuing with the SST program. The data collection process is a little bit different from what it was previously. And so with that history in mind, go ahead. I'm going to turn it over to Mike.
This is Aaron. I was just going to add that I did talk to a COSHO who's conducting an SST inspection of one company, and she thought that she issued a warning letter, but she couldn't produce it, and the client had no record of it. So it seems like OSHA's not entirely even sure if warning letters are going out.
And, that kind of makes sense because these letters do come from the national office, and so they don't come from the area offices. So there could be a disconnect with regards to what the national office and the area office is doing. So they would certainly be, typically, they come from the area office, or I'm sorry, let me clarify. They come from the national office, but there's nothing that would limit, I guess, an area office from sending those letters out. I've typically not seen that, but it's a possibility. And that could also be why there's a disconnect between the two. Now turning over to Aaron for the next part of the webinar.
Actually, this is Dan. I'm going to be covering quickly the e-record keeping portion, and I think it's important to go over this part because the e-record keeping rule is the basis for the SST program, and it stems from the data that's collected from that rule. So we're going to go over this rule in the next couple slides, in particular the data submission piece. So as you all are probably well aware at this point, this rule has been around for a while now, particularly controversial in the OSHA world, and it was promulgated back in May 2016, and the data submission elements went into effect immediately. As part of the data submission requirements, there were two major provisions. The first one was that establishments with 250 or more employees must annually submit their 300, 301, and 300A data. The second requirement was that establishments with 20 or more workers in high-hazard industries were required to annually submit 300A data. And that high-hazard industry was specifically defined in the rule determined by an establishment's NAICS code, and that's defined as the primary business activity done at the establishment based on the share of production cost or capital investment. In determining whether you're a covered establishment, these two provisions that you see on the screen here are the guideposts to determining whether you are subject to the data submission requirements and whether they apply to a particular establishment. Really quick before we go on to the next slide, we often get a lot of questions about the definition of what is an establishment. So the data submission requirement is tied to individual establishments, which is defined as a single physical location where business is conducted or where services or industrial operations are performed. So we're not looking at an employer as a whole. An employer can have multiple covered establishments, and each establishment's coverage under the rule needs to be analyzed on a location-by-location basis. So there's no problem if the headquarters or a main office is maintaining the OSHA record-keeping data, but that analysis about each particular location is establishment-specific. So this next slide here, we're going to go over the original intent of the data submission requirements and kind of what the overall purpose of the rule was and what ultimately led to this site-specific targeting program. So the data is submitted through OSHA's injury tracking application, which can be accessed via OSHA's record-keeping webpage. It was intended to be a secure website that protects employer data. Maybe some of you remember OSHA actually had some problems with the injury tracking application in its early stages when it was being rolled out. The Department of Homeland Security actually informed OSHA that there was a potential security breach, and the website was taken down for a few weeks. And this was, of course, right after it was professed that the data would be secure, and during the notice and comment period there was a lot of concerns about employer data and privacy concerns. So this was a big moment over the course of rolling out this program and the history of the rule, but it seems that it's been worked out and the kinks are no longer an issue. OSHA also indicated that it would attempt to scrub employee identifying information, but since 300 and 301 forms are no longer required to be submitted, which I'll dive into in a couple slides here, this also is no longer a major concern. The security concerns and privacy issues were a contributing factor to making the decision to ultimately amend the rule over the past year and eliminate that requirement for large employers to submit 300 and 301 data, and that certainly provides employers a bit less of a burden and some reprieve from the original intent of the rule. OSHA also intended to publish the data on a website in which the public could access it and it could be searched by anyone, but that's no longer the case. When the Trump administration came in, they signaled that was no longer going to be the case. But with that being said, you should take note and closely follow a case that was filed in the U.S. District Court for the District of Columbia by Public Citizen, and that concerns FOIA requests. So we'll cover that in a little bit more detail later in the presentation. But the nuts and bolts of that case concerns the Trump administration not providing data in response to FOIA requests and whether they're justified in doing so under one of the FOIA exemptions. It's become a major concern and a loophole for plaintiffs' attorneys, unions, and the public generally to access that employer data. So keep a close eye on that case and the potential outcome, as it could have a pretty big impact on overall access to employer data, injury and illness data in specific. Finally, the last bullet on the slide here, one of the primary reasons for collecting this data was for targeted enforcement purposes. And originally it was unclear how OSHA could possibly manage all the data that they were going to be collecting. It was anticipated that they were going to be receiving data from close to 500,000 establishments, but they have followed through on this, and that being the site-specific targeted inspection program, the SST program. So this slide demonstrates the number that OSHA anticipated receiving per year and what they're actually receiving. So the rule originally estimated that it would be that they would nearly quadruple the number of establishments submitting data to the Department of Labor, but that simply hasn't been the case, at least in the past 3 years, the first 3 data submission dates. So as you can see on the slide here, they expected to receive, close to 500,000, more than 500,000 submittals. But during the first year, they only received about 215,000. The next slide will show you that they received about 260,000. So even in the second year of the data submission requirement, there hasn't been anywhere close to what was expected. And there's a couple reasons for that, especially as it relates to the first year. There was the less than smooth rollout of the injury tracking application, and there was a lot of changing dates and deadlines, especially as it came closer to the end of 2017. And one other major contribution to the lack of submittals could have been the state plan confusion and lack of adoption of the rule itself. During the first year, there was, I think it was close to 12 state plan states hadn't adopted the final rule by the time the first data submission deadline came about. And even during the second data submission deadline, there was a number of states that still hadn't, including one large state, and that being California. So there's a lot of different factors at play of why the submission hasn't gone according to plan, but that hasn't stopped OSHA from going forward with its targeted enforcement purposes and seeking out employers that haven't submitted that data. So here's the data that we have for the first two data submissions, and those were the 2016 300A data and the 2017 300A data. And as I mentioned on that last slide, we do have a bit of an increase in the total number of submissions, 215,000 the first year, up to 260,000 the second year. We don't have the current data for the most recent submission deadline, which was this past March 2nd, just a couple weeks ago, March 2nd, 2019, but we're anticipating that it's somewhere in that 260 to 300,000 range. An interesting note here is the numbers on the far right of those two, and those are for out-of-scope submissions. 52,000, a little over 52,000 out-of-scope submissions in 2016, and close to 61,000 out-of-scope submissions in 2017. And those are mostly employers with fewer than 20 employees that weren't even required to submit data. In other words, they weren't even covered under the data submission requirements of the E-Recordkeeping Rule. Amanda and Aaron are going to cover the framework of the SST program, but it's just a quick preview, I guess. It's based solely on the 2016 data right now. So if you weren't subject to the rule, then OSHA is not going to be inspecting that establishment under the SST program. So really we have data from only about 165,000 establishments to work with, and a large chunk of those, you see 76,000 of them, are under state plan jurisdiction. So what we've seen since the Trump administration has taken office is a bit of a change in course, and this rule's had a lot of twists and turns since it was promulgated in May 2016. The Trump OSHA signaled its intent to revise the rule in its regulatory agendas, and industry had hoped for a long time that there would be significant changes to both the data submission requirements and the even more controversial anti-retaliation provisions, which included provisions related to post-incident drug testing, safety incentive programs, and injury and illness reporting procedures. But what we got was, over this past summer, in July 2018, a notice of proposed rulemaking, and there were two simple changes that were proposed. One, to eliminate the requirement for large establishments, those with 250 or more employees, to submit their 300 and 301 data, which had never, it was a requirement under the original rule, but that requirement had been suspended for the first two data submission deadlines anyway. So no one had been submitting 300 or 301 incident reports, and this was basically maintaining the status quo. And the only other amendment to the rule was requiring establishments to submit their employer identification number. And that rule was finalized in January 2019, adopting both proposals. What the final rule didn't do was address anything related to those anti-retaliation elements, which a lot of employers feel is the more controversial part of the rule and more difficult to grasp what OSHA is seeking. And just the final bullet there is, if you did have a covered establishment this past deadline, the March 2nd, 2019 deadline, you weren't required to submit your employer identification number on the ITA portal. That's because it wasn't set up for it yet. So even though that rule was amended prior to the submission deadline, that provision didn't kick in. So you'll see that the next deadline, which is March 2nd, 2020. So this is just a quick overview of the past few years, the key data submission deadlines and a history of the rule. We're not going to go over this too much because we've kind of covered it over the past few slides, but you see 2016 and all establishments, regardless of size, were only required to submit 300A data. During that 2017 data collection year, so for the July 1st, 2018 deadline, those large establishments were originally intended to submit, or originally required to submit 300 and 301 data, but that provision was suspended. The ITA portal wasn't even set up to collect that data. So again, in July 2018, information was only collected, or 300A data was only collected. And then 2018 data, 300A data, which was just collected a couple weeks ago, only 300A data, and that was after the amendment to the rule. And March each year going forward will be the data submission deadline, so March 2nd, 2020, and so on. Finally, we'll just cover quickly the enforcement policy related to the data submission requirement. So OSHA's national office on February 21st, 2018 issued an enforcement memo to the regional administrators regarding their policy for non-responders. So those that did not submit data even though they were required to. They were covered by the rule. So as part of any on-site inspection, OSHA instructed its COSHOs, the compliance officers, to inquire whether the establishment had electronically filed its 2016 300A data. If the compliance officer learned that the establishment was required to submit that data and failed to do so, OSHA would issue an other than serious citation for failing to comply with the regulation. So there was a couple different rubrics that you can see here with regard to what type of penalty you would receive. So if you encountered an inspection and a COSHO asked you for your 300A data, you were required to submit it, but you didn't. If you provide it to them on site or shortly thereafter, you wouldn't receive a penalty, but you would nonetheless receive an other than serious citation. Or if you had submitted your data for the next calendar year already, you'd be issued an other than serious citation with no penalty. So if you didn't produce data at all, didn't respond to the COSHO with a follow-up about the data, or you didn't submit for the next year, you'd be getting an other than serious citation with an appropriate penalty, but not specifically defined. So based on the current data that we've collected, there's been 122 other than serious violations for small employers, so those in the 20 to 249 range that are classified as high hazard industries. And there's been 17 other than serious violations for large employers. And Amanda touched on this earlier, but there was, and there still is, this mass mailing going out to employers who OSHA believes should have submitted data but did not, and encouraging them to do so. So maybe many of you on the call have received those. If you didn't submit data and you're discovering that you are covered under the rule, or OSHA at least believes you are, but that is still in effect, and they are issuing those mailers out to employers. So with that, I'm going to turn it over to Aaron to get into the SST program specific.
Thank you, Dan, and I'll certainly echo, if you have gotten one of those letters that Dan just referred to, that's something to pay attention to. It could very well signal that you are on one of OSHA's lists for this SST inspection that I'm going to get into in a second. If you have any questions about the letters, feel free to give us a call. but certainly everything that we've seen to date would indicate and suggest that OSHA certainly is going to want to verify or look into employers that they feel are ignoring or have not understood the requirements with respect to the electronic data submission. So that's, I don't think, really the primary, certainly not the primary focus of the SST program, but I think it is certainly going to be an integral part of it, and one that you need to pay attention to if you've gotten one of those letters. So let's start with the basics of the program. We're assuming, obviously, if you've dialed in, either you have some concern that based on your own internal review of injury and illness rates, your DART rates, that perhaps you may be at risk for an SST inspection. And we'll try to go through and do as much as we can in the remainder of the program to give you a sense of what sort of issues OSHA is going to be looking at, the scope of the inspection, how employers or sites are selected for them, and all those things, so you can kind of better assess your risks and prepare for a potential SST inspection. So as we've already mentioned, I think as Amanda covered, OSHA announced this latest iteration or version of the site-specific targeting program last fall in October of 2018. This is something that we had certainly heard rumblings about, and we're expecting the agency to do something with this massive amount of data that it received through the portal. So this certainly did not come as a surprise to us, and again, was something that we certainly expected to see. Now that the agency has all this data, almost probably more than they necessarily know what to do with, they have to figure out, or they want to figure out something to make it more productive, and enable them to better focus the limited resources that they have. So this program also, if you're a construction employer, know that the program is not focused on or does not include construction employers. It at this point is focusing on non-construction workplaces with 20 or more employees, and that means both manufacturing and non-manufacturing sites. So and Amanda referenced this as well, as far as this is really run out of the national office. So OSHA's national office is going to use a software program to generate a list of targeted establishments for enforcement from this pool of data that Dan's been talking about, and we'll send those lists to the various area offices around the country in federal OSHA jurisdiction states. The lists will include establishments with DART rates above an undisclosed threshold, and there is our understanding that there will be different rates or threshold rates for manufacturing establishments and non-manufacturing establishments. Now, one issue that is unresolved or unclear to us, and we've done our best to figure this out, but we haven't been able to determine what really get us a straight answer from the agency, is whether if you drill down below, so assuming you're in one of those two buckets, either a manufacturing site or non-manufacturing site, is whether the agency is going to have different thresholds based on your NAICS code. It's not clear to us whether that's the case or not, and at this point we're assuming that it may just be the two buckets, but that remains to be seen, and we don't necessarily expect, it's not clear whether OSHA will ever release that information or provide any more insight into whether they are differentiating between perhaps a metal stamping facility versus a coatings manufacturer versus a plastics manufacturer. So the lists that OSHA will be generating will also include establishments that the agency believes have failed to submit 300A data for 2016, as well as a random sample of establishments with low injury rates that the agency wants to verify the reliability of said data. And I think it's important, that second category, just referencing back to what Dan was discussing, it's not insignificant that the agency has received upwards of 300,000 fewer uploads than it expected. So I certainly think that one of the things that they are going to be looking on in running these inspections and going through these lists is trying to figure out where that disconnect occurred. Did they overestimate, or is under or failing to report a significant problem? And so that's something else to keep in mind. I think perhaps the most important takeaway, at least for my clients that have already been going through or currently going through SST inspections is to make sure that you understand that these inspections will be comprehensive in scope. And that means, in essence, a wall-to-wall inspection, or one at least in which OSHA is going to look into a number of your programs, policies, your procedures, different aspects of your operations. Based on the SST inspections that I've been involved with so far, I would expect that OSHA will, and after reviewing your establishment 300 logs, likely going to focus on any hazards that they suspect may exist based on the injury and illness data contained in the logs. For example, if the COSHO notes a number of injuries on a certain machine or in a particular department or performing a certain task, they may well focus there or at least begin the inspection there. That said, they may have other ideas based on your establishment's inspection history, prior incidents, prior litigation, any number of things. Even if they do begin in a certain area based off the information in your logs, that there is nothing within the program that will preclude them from expanding it even further and really conducting a true wall-to-wall inspection. And for those of you that have participated and listened to prior webinars, particularly those that we've provided with respect to managing inspections, you know that we like to talk about the importance of managing the scope of an inspection. Your ability to do that, to prescribe or limit what OSHA can or can do at your establishment is limited here given the nature of this program. Understand also that these SST inspections may be coordinated with other national emphasis or local emphasis programs. So if your establishment is selected for inspection under the SST 16 and as well as a programmed inspection, they may run concurrently, but be classified separately. And that really is more of an internal tracking issue for OSHA in terms of how they classify the concurrent inspections that are taking place at your site. It's obviously a little comfort to you as the employer when you're being inspected. And so what that essentially means is they may show up for the SST inspection, and if you also show up on the list for the amputations NEP or a local emphasis program on forklifts, powered industrial trucks, et cetera, that they will likely internally be checking both boxes on their to-do list, if you will, but they're going to be conducting comprehensive inspections of both aspects. Targeted establishments will, however, be deleted from OSHA's list if the establishment is, and this is kind of a no-brainer, is no longer in business, or if you have received a comprehensive safety or health inspection within 36 months of the creation of this current inspection cycle list, if you are a VPP or SHARP participant, or, and I don't know that this applies to any of our listeners today, a public sector employee, whether that's a federal, state, or local government agency. Employers should, again, as Amanda said, not be surprised by OSHA's site-specific targeting program. Again, this is not a novel program for the agency, and really this is the grandfather of all OSHA enforcement emphasis programs. And I think as Dan covered, prior to 2014 or 2015, SST programs used illness and injury information collected under the former ODI or OSHA Data Initiative to target the agency's inspection resources. The current version of the SST is laid out in a directive that was published last fall, and you'll be happy to know that we've poured over every page of the directive, so you all don't have to. And as you might expect, or certainly we can report, that there's really nothing terribly enlightening in the directive. It really essentially details how the lists are generated, how employers will be deleted from the list, the scope of the inspection, basically everything that we're covering in today's webinar. It's also important to emphasize that OSHA believes that the SST program helps the agency achieve its goal of ensuring that employers are providing safe and healthful workplaces by directing, and as I mentioned before, directing the resources to those workplaces with the highest rates of injury and illnesses. Now, of course, that assumes that the injury and illness data submitted directly correlates with a flawed safety program. I think OSHA seems to certainly thinks that it does, and that's part of the purpose in rolling out the SST. But it does not necessarily do that. And I think, as we've often noted and discussed in some prior webinars, this doesn't take into account injuries that occurred perhaps because an employee was under the influence while operating a forklift, engaging in willful misconduct that violates a well-stated safety rule. In essence, there may be some opportunity for you in the course of, whether that's the opening conference for the SST inspection or during the course of the inspection, to try to demonstrate to the COSHO that although you may have DART rates that are higher than whatever this undisclosed threshold is, that there's a reason for it. It's not because your safety programs are flawed. It's not because you're not complying with the applicable standards to your establishment, but perhaps that there were some unusual events. And certainly that sort of approach would help if the 2016 data on which they're basing, which got you onto the list, is an outlier, and you can demonstrate that either prior or subsequent years that you had a significantly lower DART rate. So one takeaway for me, at least, and if Dan or Amanda have anything to add, by all means jump in, is that employers should understand that there is, in essence, a no-fault aspect to your 300 data that you've submitted. In other words, if you have a high DART rate, you run the risk of being inspected, even if the reason your rates are higher than normal or higher than they were in the past is because of things beyond your control. And so again, I would just encourage employers to really dig into the data that you've submitted, be knowledgeable about, if you have a higher rate, what might be the causes of that, and be prepared to discuss that with OSHA if and when they show up.
Right, and just to follow up on that, and I see we had a question about this in the chat. It's based on your 2016 308 data. So if you are looking at your data and you're saying, oh wow, I had a relatively high DART rate, and compared to years past for 2017 or 2018, that's not what you should be looking at this time. It's at least for the SST program scope. It's the 2016 308 data that you submitted back in 2017.
Yeah, and that's a good point. And there's certainly a good, and that's a great point actually, there's such a lag in the data that the agency is using here. When we talk about leading indicators and lagging indicators, this is one that's lagging way behind. So if you're a company that focuses on the recent past and the future, this data may be something that you've evaluated and processed obviously years ago since you submitted it back in 2017. But just keep in mind that that's what we are looking at and what OSHA is going to be focusing on. So let's dig a little bit deeper into who is subject to the SST inspections under the program. Again, as I said a few minutes ago, the agency is using software that's going to generate a list of targeted establishments for enforcement from the data, this 2016 data that we've been discussing. It's our understanding that the national office will be sending 2 lists to the area offices, both of which are randomly generated. So if the area office gets through, completes all the inspections of every establishment that is included on that first list, they will then move on to the second list. I would expect that they will focus on the first, at least primarily focus on the first category of establishments, those with high DART rates, but we'll still, again, be sure to address both the suspected non-responders that we've talked about, as well as the verification of those with, I guess, what maybe the agency may view as suspiciously low injury and illness rates. I think I find it interesting that they're that they have that much concern, that they believe that there are employers out there that are purposefully changing or misreporting their data. So certainly if that's the reason that OSHA provides or indicates that that's the category that you fall into when they arrive to open the SST inspection, I think you need to be very mindful of that because it certainly could lead to a full-blown record-keeping inspection as well. Keep in mind that we're hearing that many, or certainly our understanding, that there are a good number of area offices that are understaffed. Probably no big surprise to many of you. So your experiences may vary from office to office in terms of how thorough these SST inspections will be. If you happen to draw a COSHA who has plenty of time on her or his hands, they're in good shape in terms of meeting the other goals that they have been given for the year, you may well experience a more thorough inspection. If on the other hand, the COSHA conducting your SST inspection has a full plate, perhaps is behind on other programmatic inspections that he or she needs to complete, your SST inspection may be more cursory. Obviously there's no way to tell what's going on with the COSHA who shows up, but you may kind of glean some idea based on the scope and extent of the requests for information that he or she makes, the types, whether they want to do interviews, how many interviews, who they want to interview. But again, it's just something to be mindful of, that not all SST inspections are created or carried out equally. There are a couple of I think, interesting aspects or things to keep in mind for those that operate in industries without a permanent workplace. So, for example, folks in the landscaping business, not necessarily construction, but things that are kind of the traveling workplaces, or where you go to your clients or your customers. The establishment list for many of those employers will only normally identify the employer's central office. In that case, the OSHA's area office will, to the extent they can, try to determine what active work sites you have based on the type of work that is scheduled for each site and the length of time remaining to complete the work at those sites, and then begin their inspections accordingly. And this is something that we see from time to time as well, and it's covered in the directive. Obviously, the SST program is not intended to inspect establishments that are office-only environments. Indeed, if you are an office-only company, at least in many instances, you would not have been required to submit your data to the portal. But it's certainly going to happen that OSHA is going to show up at, and this may be an error on OSHA's side, or perhaps on the establishment or the employer's side, when uploading the data, that it wasn't clear the location of the covered establishment. And this is, I think, something that Dan talked about during his segment in terms of the establishments that are covered here. So you may have a number of different establishments, some of which are covered, some of which are not, or in terms of some of which for which you were required to submit 300-day data, and others for which you did not and were not required to do so. So it may well be that you will have OSHA show up at your main office or a site that was not required to submit the data electronically. So you really want to make sure if you have operations, or you've only submitted information for certain sites and not others, and or that the folks in your offices where they are not covered understand what to do if OSHA shows up. Make sure the right people are looped in, so you can work with the COSHA to determine the proper place of inspection, because the last thing you certainly want is to permit an inspection of a site or an establishment that either is the wrong one or was not one where data was actually submitted. So with that, I will turn it back over to Amanda to talk about inspection cycles and a number of other issues.
Thank you. Taking it back over from inspection cycles, a very exciting topic. How are these cycles and these lists being created? The data management, all of the information that's been collected from 300As that have been submitted from employers, and then also some other resources that they've accessed. All of this data that's going into this list development resides at the national office in Washington, D.C., at the Department of Labor. The national folks at OSHA are the data management folks. And so they have created this list of potential employers for inspection under the SST. They've pulled from the DART rates that in high hazard industries, the non-responders, and then as Aaron said, the suspiciously low DART rate work sites in high rate, otherwise higher rate industries. And they do a random categorization, and they send that out to the area offices. The area offices have some discretion, I believe, although it's not been confirmed, in the number they want on the SST cycle list. Once they receive that list, they are supposed to complete that list unless something pretty rare happens with, there's few exceptions. If they're unusually staffed, they have a low staff number for some reason, lower than what they're normally experiencing, or if something happens in that area office, there might be some exceptions for them. But generally, once you receive that list, you have an obligation to complete the inspections on that site-specific targeting list. I'm sure usually in years past there is some sort of formula that area offices are a target of so many SST inspections as well as other programmed inspections that they're supposed to meet. I think it's flexible. It depends on geographics, staffing in the office, number of employers in a particular area. So a lot of factors, but they're getting these lists, and they have some range on how large they want the list to be. The larger they get the list, the more flexibility they will have in completing them because of scheduling. If they go into a work site that is an employee-based complaint and they see that it's on the SST list, they could expand the inspection, but it has to be on their current SST list. So they just have more opportunities to realize efficiencies the larger the list that you get. The negative side is you have to complete that list. So area offices have some discretion on the list that they get from the national office, and once that list is started, they're going through those work sites and scheduling the SST inspections. They have to complete the list before the next directive. It's on an annual basis. Usually a new directive comes out that would be applicable to the SST program in fiscal year 2019, which would start in October of this year. The fiscal year is on a different, the federal fiscal year isn't done by a calendar year. So the inspection cycles, once we receive them from the national office, then you're off to implement them in the area office. Once OSHA shows up to do a site-specific targeting inspection, they technically under the directive have the authority to inspect every nook and cranny in the workplace. It's a wall-to-wall inspection, and they certainly, compliance officers have the ability to focus on one area more than another, but the scope is comprehensive. So as we've talked about in other webinars, you can narrow the scope based on if it's a particular incident. You're going to look at that machine, that area, that workforce. These are comprehensive for all work that's within the NAICS code that brought them there is within that scope. OSHA also has the authority to engage or decide to conduct simultaneous NEP inspections. If there is a forklift NEP applicable to the work site, they could also basically move forward with that, which isn't that. They would technically be able to look at forklifts under the comprehensive inspection SST, but they might look at it a little bit closer if they're going to be also doing a national emphasis program. I think each category is kind of a unique analysis on whether or not there's some benefit, but there could be some benefit if the compliance officers really doing a very thorough examination of all of the safety and health programs within the facility is to ensuring that they are being tagged appropriately and all the emphasis programs that would apply are being noticed in that inspection file. Because if they come back in, say, 10 months to decide to open a forklift NEP inspection, there's usually a provision in there indicating an exception to get out of that inspection based on a recent one. So it can be a unique analysis for each inspection on whether or not you want to pursue getting each SST inspection tagged with as many local emphasis programs and national emphasis programs, depending on what sort of relationship and what the compliance officer is pursuing during the SST inspection. Inspection priority. OSHA has a long-standing inspection priority. In kind of the simplest terms, it goes by imminent danger. Basically, employees are being exposed to a hazard that could result in a serious injury or fatality, and so those are their highest priority, and then they go down to fatality cases and then other unprogrammed inspections. It can be a reportable incident if you've had to call in an amputation or hospitalization or employee complaints. Those inspections are considered unprogrammed inspections, and those have a higher priority than programmed inspections, which is what category the SST inspections fall into. So there's that priority area, and if they show up for an employee complaint and that employer is on the current SST list, they could expand the inspection to the SST, but it needs to be on the list that they're working on at that time within the area office. I think asking the question or ensuring that it is probably a pretty smart thing to do to get the compliance officer to look and confirm, but I don't anticipate that the employer will be able to confirm that. They're not going to provide the list, but I think you're going to have to go on what they say when you confirm that that workplace is on the list. I think it's worth asking. Like we said, they have to move through the current list before they can move on to subsequent SST plans or subsequent lists. OSHA, each area office has its priorities, but at the end of the year, there is some review of the numbers that they've met for all the different unprogrammed inspections. So it's not as though each area office can just disregard the SST program and decide that they're going to focus or they're going to spend all their resources on unprogrammed, such as the fatalities, the reportables, and the employee complaints. They do look at numbers, so they are under some they have some responsibility to complete them. And then also, too, OSHA is going to be going into the work sites that they have jurisdiction over in state plan states. Those could also potentially show up on an SST list. And we'll talk a little bit more about state plan states, but still within the OSHA jurisdiction context here. And OSHA will continue with their other NEPs, regional emphasis programs, and their local emphasis programs simultaneously as they're moving through their SST list, and one inspection might get tagged with multiple tags. It could be an SST inspection, it could be a forklift local emphasis program, and it could even potentially involve silica. So you could have as many tags as are applicable to the work site. And as I mentioned before, there might be some benefit to having as many. Just depends on what's happening with that individual inspection. Talking a little bit more detailed with regards to the unprogrammed inspections, which we talked about, which are the imminent danger, the fatality situations, and then also employee complaints and reportables. Then you get into the programmed inspections or the emphasis programs, which the SSTs are part of, and go from there in the priority ranking. The deletion from the inspection list. Targeted establishments will be deleted from OSHA's list if the establishment is no longer in business, which it's really hard to inspect a workplace when it is no longer operating. Has received a comprehensive safety and health inspection within the past 36 months of the creation of the current inspection list, which going back to how each inspection is labeled in the IMIS system, whether it's comprehensive, whether it's partial, paying attention to those labels does have benefit. If you've had a comprehensive inspection, and OSHA does look at this, but sometimes there is some confusion, so it's also worth checking for yourself. They will not pursue the SST inspection, but it does have to be comprehensive. They also are not going to go into VPP or SHARP participant sites if they are on the SST list. and then also public and sector employees. They're not going into the firehouse or other government entities that are outside of their jurisdiction on the SST program. We talked a little bit earlier, or I mentioned in my earlier comments, the OSHA's thought or development for the SST program was to get to those work sites that have higher than average injuries and illnesses and see if they can address issues before they occur. The utility of the SST program, the data is still out with regards to this, showing that link between the two, but we'll have to see. OSHA is very early in the process for the fiscal year 2018 SST program. We learned recently that probably about 350 inspections in federal jurisdiction across the country have been initiated at this point. OSHA does have 6 months to inspect, so in the next couple months we'll probably start seeing the first sets of citations resulting from these, and we'll be reviewing to see how, if it's having its intended impact. I think that more as this program proceeds, the more inspections and the more the citations will be likely to increase. There is a provision within the directive that requires state plan states such as North Carolina, Iowa, Michigan to adopt similar programs and enforcement programs that are as equally protective as. And with looking on some of the websites, I did notice, I think it was in Iowa, to see that they have implemented a program, but it's not sure what all the states are doing at this point. They were supposed to report back to OSHA within 60 days about state adoption with regards to an SST or program or programmed inspections, and they could be doing something else. Their program might not specifically be labeled the same, but they are supposed to be doing something as equally as protective as. And now turning the slides back over to my colleague.
Great, thanks Amanda. And this is Dan Deacon again. I'm just going to cover the future of OSHA's E-Recordkeeping Rule quick and tie this all together. First, we're just going to go over a couple of the legal challenges and the uncertainty surrounding the future of the rule. So industry sued in 2 different federal courts, the Northern District of Texas and the Western District of Oklahoma, challenging the e-record-keeping data submission requirements and the anti-retaliation elements, both separately. And both cases have been indefinitely stayed pending the reconsideration of the rulemaking. Now that we have a new final rule, we do expect that there's going to be some activity in the near future on those, the extent of which is pretty uncertain. But as it relates to the anti-retaliation challenge in the Northern District of Texas, since those provisions weren't affected at all, we can expect that that litigation is going to continue forward. As for the data submission challenge in Oklahoma, it's unclear how that one's going to work out at this point, considering that the only amendment was to larger employers and the requirement that they submit 300 and 301 data. Now there is 2 other e-record keeping cases to keep an eye on. One that I referenced earlier, and that's the challenge to FOIA withholding. So the Trump administration had rejected the plan to publish employer data and didn't share that data already collected in response to a FOIA request, at least temporarily. The original justification for not sharing that was for law enforcement purposes. And then if you actually go to the case file, that justification has changed. And now it's under a different FOIA exemption, the justification for withholding that information. And that's, I believe it's exception 4 for confidential commercial or financial information. And that's going to be a more permanent solution if OSHA is successful. The other case to be aware of is another one filed by Public Citizen, and this came 1 day after the new amended rule was finalized. It was filed on January 25th, 2019, so less than 2 months ago, and that was challenging the rollback of the data submission requirement, challenging under the APA rulemaking statutes. So with that, I'll turn it back over to Aaron, and he'll kick off the final couple slides here on how to prepare for an SST inspection.
Thanks, Dan. And I think I've already referred to a number of these things in my prior portion, but just to emphasize again, there are a number of considerations or a number of different things to look at here in terms of determining whether you are likely to be a subject of an SST inspection, and then what to do if you are that indeed comes to pass. As I said before, take a look at the 300A data that you submitted for 2016 to determine if it's likely that you may appear on this list. Again, we would love to have told everybody that there is a specific threshold and what that number is, so you could know for certain. Obviously, that's not the case. That OSHA is not sharing that information, not disclosing it to anyone. So it's a bit of a guessing game. But again, if you had an unusually high rate in 2016, if your DART rate was unusually high that year, or if you've had an unusually high rate for some period of time, obviously that's one signal that you may well be going to appear on one of those lists.
And Aaron,
if you think that
I was just going to add one great way for employers to check where their DART rate lands in comparison to their competitors or other employers within their industry is to first calculate your own DART rate and then look at the BLS data. BLS breaks down by NAICS numbers industry DART rates, and that kind of gives you a point of reference to see, oh, am I higher than my competitors, or am I about the same, or am I lower than? So just so individuals that are trying to get a grasp on where they fit into their business industry NAICS code, that's a good way to go about doing it.
Yeah, that's a good point. Thanks, Amanda. Also, obviously, if you can have the ability or take the opportunity to take a look at your 300 logs, as I said before, to look for any data that might suggest trends, particular types of injuries that are occurring, particular areas or departments that have experienced a spike in injuries. That's something to take a look at. And if you believe, based on your review of the data, as well as if you're able to compare yourself to your competitors, as Amanda suggested, then obviously I would recommend going through the same sort of kind of self-audit, or perhaps even if you're particularly concerned, you can look into a privileged audit that's managed through counsel. But either way, looking at the types of issues that you have in your workplace, many of the things that we talk about in the context of just preparing for inspections generally. Look at your lockout program. Make sure that you have machine-specific procedures. Make sure you're doing your periodic inspections, that everybody's received the type of training that they should receive, whether looking at whether your equipment, your machines are properly guarded. If you have a respiratory program, making sure that people have had the necessary examinations, fit testing, if you have noise issues, just all those sorts of things. I don't have to obviously go through each one, but just know that whatever the hazards are that are particular to your workplace, that those are the ones that OSHA is certainly most likely to focus on, as well as anything else that comes up during the course of the inspection. So with that, I'll turn it over to Amanda to share some more of her suggestions and tips for preparing for the inspections, and then I think we'll be close to wrapping up. Great.
Thanks. I selected for an SST program, and OSHA's at your door, and the first thing with any inspection, we talk a lot about being prepared for inspections, and the first thing we always encourage employers to do is to have an opening conference. And in that opening conference, it's a legitimate question. OSHA is used to receiving questions like this. What is the basis for your visit today? They need to indicate why they're there. Is it there for a referral that they received related to a reportable incident or a fire that they saw on the television, or are they there for an SST inspection? And if they say that they're there for an SST inspection, it's time to compare data. Make sure that the numbers that they have reflect accurately the information that your documentation shows. Your NAICS numbers, that's another thing that's very important. We talk a lot about that, but I have been involved in inspections where the work site was misclassified with the wrong category of the wrong NAICS number, and it was not subject to the one that OSHA had, and so we did not proceed with the SST inspection. So there's a little bit more checking that needs to go on when they identify that it's an SST inspection. Look at the data, compare DART rates, and also make sure that they're operating with the right NAICS code. Also at that time, would be a great time to ask them whether or not they intend to wrap any other NEP or LEP inspections in. And making sure that you have a clear roadmap from that initial opening conference, asking them what they intend to look at, if they're going to be looking at something a little bit more specific, if they want to, generally walk the facility, do they want to walk one particular area? Those are all questions that should be asked during that opening conference and getting clarification on the SST inspection. And do remember that they do have wall-to-wall authority under the SST inspection authority once they establish that they're there on that basis, and it is a credible basis. And we talked about having other previous inspections with regards to getting out of the SST is, the last 36 months. Have you had a comprehensive inspection? That 36 months starts ticking from the time that they create the list, which is not completely a transparent date. So, there's going to be a little bit of confirming with the area office what that date is, and, if it's a close call with regards to when the last inspection was, certainly worth tracking down and pursuing, even though you're not going to get likely the date that the inspection list was generated, somebody at the area office confirming that that is the case to ensure that they have jurisdiction to proceed. OSHA and following generally OSHA inspection protocols. I noticed that we got one question coming in with regards to SST inspections, whether or not the potential 2019 program will be based on 2018 data. And I was just going to share, historically, it's been a two-year lag period. So the data that's being used currently is from 2016, and that is the 2018 SST program, and that's been typically what's happened under the old system when they were doing the surveys and paper collection. It could be that OSHA is more nimble and able to turn the data around more quickly as they continue and become more experienced with the data that they're collecting through the electronic system. But at this point, it seems to be a two-year lag period on the data that they're using. With that, that concludes our webinar for today. And as always, we're always available. Our contact information here is available on the slides, which will be coming to you in a few days via email provided. And we're always happy to entertain questions. If we didn't get to your question today, the screen participant feedback, or we didn't mention it during our webinar, please reach out to us. We're always happy to entertain such questions and share what our experience is and learn what you're seeing in the field. So with that, we conclude our webinar today. Thank you.